The view taken by the High Court, namely that even if there was an assurance given by the fourth respondent on behalf of the state government, and such assurance was binding on the state government on the principle of promissory estoppel, the appellant had waived its right under it by accepting the concessional rates of sales tax set out in the letter of the fifth respondent dated 20th January 2020 is not correct. Second, waiver is a question of fact and it must be properly pleaded and proved. No plea of waiver can be allowed to be raised unless it is pleaded and the factual foundation for it is laid in the pleadings in the instant case. Subclause A, next para. The plea of waiver was not taken by the state government in the affidavit filed on its behalf in reply to the writ petition, nor was it indicated even vaguely in such affidavit. It was raised for the first time at the hearing of the writ petition. That was clearly impermissible without an amendment of the affidavit in reply or a supplementary affidavit raising such plea. Next, B. It was not right for the High Court to have allowed the plea of waiver to be raised against the appellant, and that plea should have been rejected in limine. If waiver were properly pleaded in the affidavit in reply, the appellant would have had an opportunity of placing on record facts showing how, why, and in what circumstances the appellant came to address the letter dated 25th June 2020 and establishing that though on those facts there was no waiver by the appellant of its right to exemption under the assurance given by the fourth respondent. But in the absence of such pleading in the affidavit in reply, this opportunity was denied to the appellant. Third, waiver means abandonment of a right and it may be either express or implied from conduct. But its basic requirement is that it must be an intentional act with knowledge. There can be no waiver unless the person who is said to have waived is fully informed as to his right and with full knowledge of such right he intentionally abandons it. In the instant case, on the facts, the plea of waiver could not be said to have been made out by the state government. There was nothing to state that at the date when the appellant addressed the letter dated 25th June 2020, it had full knowledge of its right to exemption under the assurance given by the fourth respondent and that it intentionally abandoned such right. It is not possible to presume in the absence of any material placed before the court that the appellant had full knowledge of its right to exemption so as to warrant an interference that the appellant waived such right by addressing the letter dated 25th June 2020. It is difficult to speculate what was the reason why the appellant addressed the letter 25th June 2020 stating that it would avail of the concessional rates of sales tax granted under the letter dated 20th January 2020. The doctrine called promissory estoppels, equitable estoppels, quasi estoppels, and new estoppels is a principle evolved by equity to avoid injustice, where a promise is made by a person knowing that it would be acted on, and it is person to whom it is made, and in fact it is so acted on, and it is inequitable to allow the party making the promise to go back upon it. Though commonly named promissory estoppel, it is neither in the realm of contract nor in the realm of estoppel. The basis of the doctrine is the interposition of equity, which has always true to its form stepped in to mitigate the rigors of strict law. The true principle of promissory estoppel is that where one party has, by his words or conduct, made to the other a clear and unequivocal promise which is intended to create legal relationship, effect a legal relationship to arise in the future, knowing or intending that it would be acted upon by the other party to whom the promise is made, and it is in fact so acted upon by the other party. The promise would be binding on the party making it, and he would not be entitled to go back upon it if it would be inequitable to allow him to do so, having regard to the dealings which have taken place between the parties, and this would be so irrespective whether there is any pre-existing relationship between the parties or not. Equity will, in a given case where justice and fairness demand, prevent a person from insisting on strict legal rights even where they arise not under any contract but on his own title deeds or under statute. To the applicability of the doctrine of promissory estoppel, it is not necessary that there should be some contractual relationship between the parties, nor can any such limitation, namely that the doctrine of promissory estoppel is limited in its operation to cases where the parties are already contractually bound and one of the parties induces the other to believe that the strict rights under the contract would not be enforced, be justifiably introduced to curtail the width and amplitude of the doctrine. The parties need not be in any kind of legal relationship between the transaction from which the promissory estoppel take its origin. The doctrine would apply even where there is no pre-existing legal relationship between the parties, but the promise is intended to create legal relations or affect a legal relationship which will arise in future. The doctrine of promissory estoppel cannot be inhibited by the same limitation estoppel in the strict sense of the term.